You're watching The Legal Breakdown. So, Glenn, we have a whole raft of viewer-submitted questions here that were so good that we had to do an entire episode of just these questions. So let's jump in here. Let's say that Trump gets elected president in 2024 and he figures out a way to get his own DOJ to remove itself from all of these federal prosecutions of him, but he's still convicted in Fulton County, Georgia, which is a state prosecution. How can a state enforce its conviction and arrest a sitting president? Like, are we supposed to believe that the Georgia State Police are going to just walk into the White House and arrest the president of the United States?
You know, there is no playbook for this one, Brian, and I think it would be a battle royale between the feds and the states. Let's take sort of an informed guess about how this may play out, because you can't definitively answer this question until it actually happens. So there's this thing called the Supremacy Clause in the Constitution. What does that stand for? Generally speaking, it stands for the proposition that when there is a conflict between a federal law and a state law, the federal law wins. The federal law is supreme. Now, that doesn't really answer the question, but there is this notion that when there are major conflicts between the federal government and a state government, the feds usually win out. So let's just be clear that the Supremacy Clause can't really be stretched and contorted to definitively answer the question, what happens if a state convicts a sitting criminal president and imposes a sentence of incarceration? Here's what I suspect would happen. I think, first of all, Donald Trump has been an aspiring dictator for a very long time. So this is going to sound hyperbolic, but stick with me. I could see Donald Trump misusing both the law enforcement resources of the federal government and, frankly, the military resources of the federal government to keep him out of prison. And frankly, if you pit the feds against the states, the feds are going to win the battle of might. I think realistically what would happen is there would be legal challenges filed, both in state court and in federal court, and it would get hashed out between those judges. I think what would tend to happen is that the judges would say, listen, this is a valid conviction. It is a valid sentence to incarceration of a current president of the United States. What we're going to do is defer his incarceration until until his term is completed. I don't think that's a satisfactory answer. I think if I had to bet 50 cents, I would probably bet that that's the way the courts would handle this novel situation.
Okay, well, now we have a better idea as to why he's trying to push all of these prosecutions so far out into the future. Glenn, if Trump does issue some kind of an order to the Secret Service or the Capitol Police or whoever it is that he has to protect himself, even the U.S. military, where do their allegiances lie? Is it to the law, which would presumably be in favor of these prosecutors who want to incarcerate him, even if it's from Fulton County, or do they lie with the President of the United States?
Yeah, great question. They lie with the Constitution. It's an oath I took both when I was an Army JAG and when I was a DOJ federal prosecutor. We pledge our allegiance, our loyalty to the Constitution of the United States, not the president, not any one person. So I have to believe we would have enough General Millies of, this sad episode, if it actually comes to fruition, people who will stand up for the Constitution and stand up to a criminal president, an aspiring dictator. So I don't believe the men and women of either law enforcement or the military would carry out the unlawful orders of a criminal president, something, Brian, that was drilled into our heads when I entered active duty as an Army officer back in the 80s, is you have an absolute obligation to obey a lawful order, but even more importantly, you have an absolute obligation to disobey an unlawful order. I'm going to place my bet on the men and women of law enforcement and the military rather than place my bet on a criminal president.
Okay. And just to your point about sounding hysterical. I don't think anybody a few years ago would have looked at what happened on January 6th and would have taken you seriously if you said it. So I think it is important just to recognize these things and recognize that Donald Trump is capable of bringing these things to fruition if he can, because there are no limits he won't go to keep himself in power. So it's just worth talking about these things, even if it does sound hyperbolic or hysterical, because God knows that, nobody would have expected anything that we've seen thus far to have happened if you had asked us 5 years ago. I want to switch gears a little bit and bring up a different question, and this is with regard to the Fulton County case. If one of the main co-conspirators, like Sidney Powell or Rudy Giuliani, or anybody else like them up to that level, were to flip, would the district attorney really just let them go completely free of charges? Like, some of these people are equally as bad as Trump. Powell, especially with the breach of the voting machines, Giuliani by trying to manipulate state legislatures. So, I mean, are we to expect that they would just get let go if they were to flip on Trump?
I think I can answer that question definitively. The answer is no. Prosecutors are not in the habit of taking defendants who have some really important incriminating information about bigger criminal fish and giving them a complete pass for their crimes. Why don't prosecutors do it? Well, first of all, it's just not really a fair application of the law to give a significant criminal like a Rudy Giuliani or a Sidney Powell a complete pass for their crimes. But even more importantly, if we were to do that, then the credibility of their testimony would be really pretty low, because the way they would get attacked at trial is, wait a minute, the prosecutor sitting right there in this courtroom gave you a complete pass for all of your crimes. So of course, you're going to say anything that prosecutor wants you to say about the crimes of my client, Donald Trump. Your credibility is shot. We have a keen interest in trying to keep the credibility of our cooperating witnesses. That's a term of art for a defendant who has decided to plead guilty to their crimes and testify truthfully about the crimes of others. We have a keen interest in keeping their credibility high. That ordinarily means that in their plea deal, they have to take a big old bite of their own crimes before we're willing to sponsor their testimony, about the crimes of others. So these people will not get away scot-free, even if they decide to cooperate. Now, contrast that with the lower level criminal fish. Maybe some of these fake electors who have some incriminating information to provide against others, but their crimes were not nearly as serious as the Rudy Giuliani's and the Sidney Powell's. Those are the kind of people who might get immunity. What does immunity mean? It means they get a pass for their crimes, but because their testimony is less important, less consequential, sometimes prosecutors will make that tactical call.
Okay, well, with regard to another person who seems very much like a co-conspirator in all of this, why haven't we seen Lindsey Graham be involved in any of these indictments? Like, we already know about his involvement in trying to meddle in the Georgia election. Is there any likelihood that he's already cooperated against Trump and maybe that's why he wasn't charged? Or what else would explain his kind of complete disappearance from all of this when it comes to the legal stuff?
Yeah, Brian, the viewers ask great questions, and that's another great one. First of all, what do we know about his potentially criminal conduct? Most directly, what we know is that he placed multiple calls to Brad Raffensperger, just like Donald Trump placed the infamous "just give me 11,780 votes" phone call. And Brad Raffensperger made a number of public statements about that phone call, that phone conversation he had with Lindsey Graham. Here's what he said, and I think I can quote it pretty much verbatim. He said that what Lindsey Graham was saying to me sounded like he was asking me to toss out lawfully cast ballots. That is some damning testimony. However, the way it was couched, I think, left open room for interpretation. It kind of, what Brad Raffensperger said kind of sounded to me like Lindsey was urging me to commit election crimes. That is a great piece of evidence, but standing alone, that doesn't get you all the way home when it comes to charging Lindsey Graham for crimes. Here's the second important data point. Lindsey Graham testified in the grand jury. He fought against it mightily. He whined and complained and bellyached and filed motions trying to get it all the way up to the Supreme Court. Even the Supreme Court refused to accept the review of Lindsey's question, his attempt to keep from testifying before the grand jury. And basically every judge ultimately ordered him to go in and testify. They gave him a little bit of limited protection if some of the questions really did involve things like speech or debate protected information. But Lindsey went in and testified. Now, we don't know what he said, but whatever he said must have been important enough or valuable enough to DA Willis and her team of prosecutors that for whatever reason, they decided not to charge him with a crime. I suspect it's because the evidence that would prove beyond a reasonable doubt that Lindsey Graham committed a crime may have been lacking. So they may have just taken whatever evidence they could get out of Lindsey in the grand jury, and he could very well pop up as a trial witness against Donald Trump and all of the other co-conspirators when the Georgia case goes to trial.
So in other words, his testimony might have actually lent itself to Trump's prosecution, which may explain why he's going so hard in the media to overcompensate in the other direction, because he knows that he may very well have been an accomplice in helping to take down the guy who he now is trying to protect with everything that he's got. Okay.
I don't credit anything that Lindsey Graham says these days. I mean, I really think the only thing he contributes to any conversation is carbon dioxide.
Right. Okay, another great viewer question. Donald Trump has 91 charges against him. How is this guy not a flight risk?
I think he is a flight risk. Now, the counter argument is he's got the Secret Service watching over him 24/7. So how could he flee? Because he can't shake Secret Service protection. That's for darn sure. So, I don't think he is a flight risk as much as I think he's a danger to the community. And people should know that there are two reasons, or there are two separate reasons a judge can order somebody detained pending trial, jailed pending trial, if there's clear and convincing evidence that he's a flight risk, or if there's clear and convincing evidence that he's a danger to the community. Donald Trump is perhaps the most dangerous pretrial defendant to the community, to our nation, at this moment in time. I hope at some point, some of these judges sit up, take note of that fact, and consider ordering him detained pending trial.
If Trump did flee and he was ordered to court and he did have a Secret Service detail, would those people then go from protecting him to then basically defending these court orders and be there to return him to the United States if they needed to?
Yeah, they're sworn to protect the president, but their loyalty is to the Constitution and the rule of law. And I would not bank on them protecting a runaway, literally runaway president. They would do what they had to do to enforce the rule of law and to serve the Constitution.
Okay. One more viewer submitted question, and that is moving over to the Washington, D.C. trial. Is there any chance that trial could be televised?
I actually think there is a better than 50% chance. Here's why I say that. You can make the equitable arguments, right? The equitable arguments, not arguments based on the law, would be, listen, this is the most important criminal trial in our nation's history. I feel comfortable saying that. And the American people really have not only a right to know, but a need to know, because they're going to be making their life decisions based on what happens in the courtroom. They're going to be making their voting decisions based on what happens in that courtroom. And we need to see this trial, because if we don't, you know what's going to happen? Donald Trump's defense lawyers are going to step to the cameras at the end of every trial day, and they're going to put disinformation, propaganda, and outright lies into the public square. They're going to talk about how, again today, the prosecution's evidence fell apart, proving once again, this is a witch hunt. This is political interference. You know what Jack Smith's team of prosecutors will say at the end of every day?
Nothing.
Nothing. They will say nothing, because they're not permitted to speak about a trial while the trial is still ongoing.
Which creates a vacuum that's going to be entirely filled by Trump and his allies.
And it will be a one-sided fight. It will be, the DOJ fighting with one arm, tied behind its back. That's another equitable reason that the American people should get to see the evidence with their own eyes rather than relying on what anybody says about it, including mainstream media. We need to see it for ourselves. Here's the legal reason, the statutory reason that I believe cameras may have to go into the courtroom. There's something called the Crime Victims' Rights Act. It's the Victims' Bill of Rights. It's a federal law, and it gives victims statutory rights in court proceedings. Now, you might say, well, who are the victims here? This is the beauty of it, and I expect we may even see a legal suit filed along these lines. The courts have decided that in voter fraud cases, particularly things like a conspiracy to deprive people of their voting rights. Sound familiar? It should. That's count 4 of Donald Trump's indictment in Washington, D.C. The courts have said regarding that crime, the voters are the victims. Well, guess what? The Crime Victims' Rights Act gives we the people, the American voters, the statutory victims, the right not to be excluded from the courtroom, the right not to be excluded from the trial proceedings. If the trial is not televised, we will all be excluded from the proceedings. That is not a stretch of the law. That is a heartland argument that is supported by the Crime Victims' Bill of Rights. It's paragraph number 3 in the 10 rights that are enumerated in that federal law. So I think we're going to see a groundswell, both equitable and legal, for cameras in the courtroom. And I kind of like the odds of cameras ending up in the courtroom at the end of the day.
Glenn, who makes that request and who grants that request?
So there is an organization called the U.S. Judicial Committee. It's headed up by Chief Justice Roberts. So it would be a vote of the committee members. And then I think it would ultimately come down to Chief Justice Roberts saying yay or nay. I don't know everything about the bylaws and the precise ins and outs of the voting procedures, but it will be largely up to that judicial conference as headed up by Chief Justice John Roberts.
Okay, well, we'll leave it there. To everybody who submitted questions, thank you so much. Obviously, these questions were good enough to warrant their own episode. If you check out the community tab on my YouTube page, you'll see a post there requesting more questions. So if you have any questions that you want an answer to, you can respond to the post on my community tab where I basically solicit more questions so that we can do more episodes like this. So with that said, for more episodes like this one, make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.